The next case on the call of the docket this morning is agenda number 19, number 126802, in re the marriage of Sandra D. Dahm-Schell and Mr. Mark Schell. Dustin Stephen Hudson, when you're ready.
Your Honors, may it please the court, counsel. My name is Dustin Stephen Hudson, and I'm here on behalf of Mark Schell. We're here today to ask the court to overrule the 5th District, which has decided that mandatory retirement withdrawals that are taken from an inherited account are to be included in income for purposes of calculating child support and maintenance. A little history in this case. The case was originally brought in the circuit court in August of 2014 when the petitioner, Ms. Schell, filed for dissolution of divorce. My client, Mark Schell's mother, had died in March of 2014, at which time he inherited a substantial amount of assets, including some retirement accounts. In October of 2016, the court entered a dissolution of marriage for the parties and awarded my client his non-marital inheritance from his mother, which the parties stipulated to in the divorce proceedings. That decision, there were motions to reconsider that were filed by both counsel, and those motions were subsequently denied in December of 2017. There was an amended judgment and a second amended judgment that was entered at that time, approximately 10 days apart, both denying Ms. Schell's request to be awarded funds from the inherited accounts. Mr. Schell, due to the nature of the accounts and that he had inherited, was required to take distributions from those accounts, the required mandatory withdrawals, which are now were being withdrawn, sent to him on a monthly basis. The argument was initially appealed after the court had ruled that those mandatory withdrawals, sometime after the divorce was entered. So the divorce was entered, the motions to reconsider were filed, they were denied. Over 30 days had passed, they became final. There were still petitions, there were new petitions pending to modify the maintenance and child support at that time due to Mr. Schell being laid off from his employer. At that point in 2018, there was a hearing wherein Judge Keevlin in the circuit court determined that the automatic or the mandatory retirement withdrawals that Mark was forced to take from these accounts were not income for maintenance and child support purposes. That was appealed by Ms. Schell to the 5th District. The 5th District dismissed it at that time as they said it wasn't a final ruling. The circuit court under Rule 308 certified the question back to the 5th District, which the 5th District accepted. The question that was certified back to the 5th District was whether inherited mandatory retirement distributions are income for purposes of child support and maintenance calculations. When the 5th District issued its ruling, they amended the question slightly and amended it to state whether mandatory distributions or withdrawals taken from an inherited individual retirement account containing money that has never been imputed against the recipient for the purposes of maintenance and child support calculations constitute income under 750 ILCS 5504B3 and 750 ILCS 5505A3. The court, the districts, the several districts have literally been all over the place in determining whether or not IRA distributions, required minimum withdrawals, are income for child support purposes. In 2005, the Lindman Court stated that that IRA distributions were income for calculating child support and maintenance purposes. They also expressed a concern in a potential issue of double counting at that time, and what they stated was there could be an issue if the individual had been placing money into the retirement accounts at the same time that he was paying child support and maintenance, only to subsequently withdraw accounts from those funds that had already been considered. And that was the exception that they gave when they stated that they were. The 4th District in 2011 in O'Daniel was faced with essentially the same question, and they stated that IRA distributions were not income for child support and maintenance purposes. And the reason they gave is they stated that these accounts already belong to the owner, that you can't, it's not income when you're merely receiving what you already own. And that was the key in deciding that in the O'Daniel case. This court has addressed it slightly. They didn't address it in Marriage of McGrath. It was a question about whether or not a savings account withdrawal and the individual's withdrawals from the savings account would constitute income. And the court in that case, this court, stated that those were not income for child support purposes. They stated that the money in those accounts already belonged to the individual owner, and if they already belong to the individual owner, as stated in the McGrath case in this court, that they could not be income. The money was already belonging to him. They did recognize an issue, a potential issue, with the court being concerned that maintenance or child support wasn't going to be paid if that was the only income from the non-custodial parent. However, they said that's exactly why the legislator included deviation factors, that it's an asset, it can be considered, but the mere action of withdrawing the money from a savings account does not impute it as income.
Can I ask you a question? Are
Sure.
any of the cases that you cited based on an account that was funded by an inheritance?
Not specifically an inheritance, other than in Cooper, which was the next one. In Cooper, the trial court, and that was in the 3rd District, the trial court had used the individual's income or expenses that he was expending to get to what his income level was. And the court in that case said that the trial court expressly stated that it did not consider the withdrawals as additional income, and it relied on the inheritance he received and the financial opportunities that those assets provided him. In essence, the court deviated from the standard. So they didn't count them as income, they deviated. And in this case, and in Marriage of Mayfield, this court stated that income includes gains and benefits that enhance a non-custodial parent's wealth and facilitates the parent's ability to support a child. But a withdrawal from an IRA, whether it's yours, whether it's inherited withdrawal, when the account already belongs to you, when the money already belongs to you, a mere withdrawal of money already belonging to you doesn't enhance your wealth. In fact, it could decrease your wealth, as the markets could fluctuate on a daily basis, but under the federal tax code, you're required to take these mandatory minimum withdrawals, or you're required to pay 50% tax on what you don't take.
You know, the concern in those other cases was double counting, right?
Yes, Your Honor.
Double counting. In this situation, this isn't double counting, is it?
Well, it would be double counting, and in the Verhines-Hickey case, they sort of addressed both of those. So they addressed Lindman, which said double counting, and they addressed O'Daniel, which said that it's not income. And in that case, they said they don't feel like Lindman and O'Daniel are opposite, that they feel like a percentage of it could be included for both. Number one, if you subtract it for the double counting, and number two, in O'Daniel, they said the interest and appreciation could be income. The problem you have is the type of accounts, the double counting issue. And then if you go to McLaughlin, which was 2012 in the 1st District, McLaughlin came to the decision that it was income for child support purposes, it was not income for maintenance. And the reason for maintenance was the retirement accounts were awarded to the individual in the divorce settlements, making it based.
Didn't they parties stipulate that this was non-marital property at some point? When was that?
They did, Your Honor. At the time of the divorce, they stipulated, and I believe the trial was in April of 2016, they stipulated that it was non-marital and it was awarded to my client. He had actually inherited it approximately 6 months prior to the divorce proceedings even starting. So in March of 2014 is when his mother passed away and he inherited the accounts. The divorce was filed in August of 2014. In April of 2016 at the trial, the parties stipulated that it was non-marital funds, it had never been commingled, and it was to be awarded to my client. So at that point, it was confirmed that it was merely his asset. It was his asset back in March of 2014 when he inherited it. It never changed ownership. It was always his account. And then
The trial court at the time of judgment could have considered this asset in deviating from guidelines, correct?
absolutely, and we believe they did consider the asset when they,
Well, the Fifth District seemed to think that there has to be some affirmative statement or something of the trial court saying, well, that I've now considered this. I mean, that seems to be the thrust of it.
yes, Your Honor, and we would disagree strongly with that. The statute requires you to lay out the reasons for deviating. So if you deviate from the statutory amounts, you're required to lay out those reasons within the judgment of dissolution. The court in this case, they deviated slightly, but not based on that. They imputed some income to Ms. Schell, and they laid that out in there as to why they were doing it, and there was a slight deviation. And our argument would be that you don't have to state specifically why you're not deviating. The statute doesn't require that. In addition, in the motions to reconsider filed by Ms. Schell, she specifically requests a percentage of those funds, the 32% or 28%, depending on the number of kids that were still minors at that time, and the court denied it. The court denied that in their amended judgment and second amended judgment. So I would disagree with the Fifth District that it wasn't considered. It was considered originally. It was considered again in those motions to
And
reconsider.
then once withdrawals are being taken, again, the other side could come back on a petition to modify and again ask to go outside of guidelines, to deviate from the guidelines based upon, let's say, the withdrawals are huge. But again, the question here is whether we're going to include these in the guidelines.
Correct. The question is whether or not it's income, Your Honor. I don't disagree. It's an asset that the court could review for potential deviation. The problem you get in including it in income is these are mandatory withdrawals. They're mandatory based on the calculations provided by the federal government that say you have to take X amount of dollars or you're going to get taxed 50%. My client's testimony was he takes them and just immediately reinvests them into an account that he doesn't have to take those funds out of, but he does it to avoid the tax consequences. Otherwise, the account would essentially be depleted for taxes. So as far
So you're saying there'd be a difference if he's voluntarily took them versus taking them based on tax requirements?
So there wouldn't necessarily be a difference, and that's our argument, is that all IRAs should be treated the same. So whether he's required to take them or whether he's voluntarily taken them, it's still an asset. Our opinion is it's not income. It's an asset that the legislator has made available, these deviation factors. One is the financial resources of the parties, that they can absolutely consider if the guidelines don't feel the guidelines support the children. In addition to the maintenance argument, those funds were, as Your Honor stated, stipulated in court that they were non-marital, that they were to be awarded to my client. So to now come back and say, but now they're income, and Ms. Schell can get a portion of those through basically backdoor means because she didn't get them in the original divorce, would be unfair. Additionally, when he inherited them in 2013 or 2014, I apologize, when he inherited them at that time, there were other accounts. There were some bank accounts. There was a money market account that's outlined in the judgment. Had he removed the money, the same money, had he removed it, had he placed it in the savings account, it wouldn't be an income. So it doesn't make sense to argue that now it's income because he's getting it as he is, as opposed to just removing it when he got it. Public policy favors individuals saving for retirement, favors them not relying on state aid down the road, and that's what he did. He saved the amounts for retirement, or so they would accrue, and hopefully grow. And that leads me to my next situation, is trying to determine, and in the conflict of cases, trying to determine what amount you are taking out is actually appreciation, or is actually, it's easy to determine interest, it's easy to determine dividends, though they calculate that for you. But if you put $25,000 in an account and 10 years later you're withdrawing it, but it's got $100,000 in the account, and you never put anything else in it, what money was put in there originally? What money is the appreciation? How do you calculate that? And I think that's going to make it very difficult. You're going to almost have to get an actuary to come into every divorce case and say, here's how much of the money was originally put in, here's how much is coming out of the appreciation, what it gained. By the same token, if it loses money, if you put in 50 grand, 70 grand, and it loses, and when you start withdrawing it, it's only got 45,000 in. Well, how much of that, is it all a loss? Is there 5,000 that's a loss? It's going to make it very, very difficult to determine these cases. It's also going to have a massive effect on people who are already retired and taking IRAs who are paying permanent maintenance, because this will open them up to an additional petition to modify to take into account all these sums that they put in previously that they're now receiving back in retirement. In regards to
Counsel, at the end of the day, aren't we guided by Section 505A of the Act, which defines netted income for child support as the total of all income from all sources? Isn't that definition broad enough to include mandatory minimum withdrawals?
And I would disagree with that, Your Honor. I understand we are guided by that, and I do agree that it would include all income from all sources. The question is whether or not the IRA withdraws income. It's merely a return of principal. It's a return of his investment. He had the money. It was his. He invested. Well, it was invested, and the money is simply being withdrawn. And it's our position that it is much more similar to a savings account, that it's not. It could decrease, it could increase. You don't know what it's going to do on a daily basis. It's all depending on the market. But that doesn't change the fact that these have to be withdrawn at some point. He could, in theory, he could withdraw any of his retirement accounts at any point. But to say that that's now going to be an issue when it comes to maintenance and child support, he would essentially be stuck with leaving his retirement accounts in there indefinitely. He's ordered to pay permanent maintenance. So Mr. Schell, at this point, if he were to ever withdraw his retirement accounts, it could be a petition to modify, and we could be back seeing how much he withdrew for his living expenses. And that's why it makes so much more sense that it would be used as a deviation factor. The court, it's not saying it's immune to the court considering it. It's saying that it's not automatic income. And when the court made their decision in this case in Mayfield, it said that its income is something that increases a parent's wealth. This doesn't increase his wealth. In fact, it may decrease his wealth. If the market skyrockets the day after he takes one of those mandatory minimum withdrawals, he's lost money. Or if it tanks the day before he takes one of the minimum mandatory withdrawals, he's lost money. There's no way to figure out specifically what is a gain and what is not a gain in these accounts.
Well, when he takes it out, and any time it's taken out, at that moment in time, there'd be a percentage of that amount to the amount in the account, which would represent an increase in the account based on increase in the stock market, increase in whatever investments there were in the account.
So
That'd be the principal, a difference between the principal and the increase. Is that right?
maybe, correct. And I think I understand the question, but in the event these monthly withdrawals, it's going to be different every month. So there's not going to be.
I'm saying, would that matter to you in your analysis? It could well be, of course, different every month because there was X, the principal amount that he inherited, right?
Correct.
Okay, and then since then, there'd be X plus based on market trends, right?
Or X minus, correct.
Or X minus.
Correct.
So anytime there's a distribution, it would be part of one thing and then part of another thing, right?
Well, that would be the issue. One of the issues is you'd have to calculate that. How much is it taken out? Is it FIFO? Is it LIFO? First in, first out, last in, last out. How are they calculating this? Is the money you put in there the principal? Is that sitting? Is that money you're not touching and you're taking the appreciation? It's just going to be very difficult to determine what's in there.
It might be difficult, but people do that, don't they? That's what accountants do that.
Yes, I mean, they do determine here's the gains, here's the losses. The problem is, in this context, it would be a monthly, you'd be coming back to court every month to say, I need to modify my child support because I had to take $600 this month, but my account lost $2,000. Or I had to take $600 and the other party's filing because your account went up $3,000.
I'm just trying to understand from the way that you're arguing in this case, this would seem to be a factor, right? Sometimes it would be a gain, sometimes maybe it would be a loss. So therefore, there would be, under your view, there wouldn't be any generated income for calculation purposes. But otherwise, there would be, right?
Potentially, yes, Your Honor. It depended on whether there was a gain or loss in the account and which money was being withdrawn.
I mean, that would seem to be in accord with your analysis.
Correct, I believe so, yes. I see my time's up. Thank you.
Thank you, counsel. Ms. Viss?
Thank you. May it please the court, counsel. My name is Rhonda Fiss, and I represent Sandra Schell, the appellee in this case. I would first like to address the issue of whether the property that Mark Schell inherited, whether the classification of it as non-marital has any bearing on the issue before this court. And I submit to you that it does not. First of all, non-marital property is specifically not excluded under Section 505A, which is the statute that controls what income can be considered for the purpose of child support. Secondly, I would note that legacies, inheritances, gifts are also considered non-marital property. And what counsel has failed to bring before this court is its own decision in the case of the Marriage of Dahm-Schell, decided in 2004. In that case, the father was receiving cash from his parents on a regular basis. These were gifts, and the court was asked to determine whether these gifts should be included in the child support calculation. Mom was asking for an increase in child support. Dad had argued, no, they should not be, because these gifts can't be relied on, and they really don't increase my wealth. This court disagreed. Practically, as a practical matter, it said, it enhances your wealth. When we decide what is income under Section 5505, what we determine is, based on the plain language of the statute, whether wealth is enhanced, it is a benefit, it is a gain. In other words, what effect does it have on the party who's receiving this money?
Rogers was post-dissolution, was it not?
Yes, it was.
I mean, isn't that the issue here? You know, everything is a gain if you're gaining it at some point in time. If this IRA had been inherited post-dissolution, it would be a gain. It would, just like Rogers, it would be income, it would be a gain. But the issue really is, when does it happen? If it happens pre-decree, and the trial court has the ability to look at the entire estate and decide what the support obligation will be, and then awards different things and awards that asset to one party, like McGrath. Why isn't this like McGrath?
I think that McGrath speaks to this in particular because in McGrath, this court analyzed whether a savings account should be considered income for purposes, withdrawals from the saving account should be income for purposes of child support. And their focus was, number one, an important fact that can easily be overlooked in McGrath, that the account had accrued during the marriage. In other words, the contributions that were placed into the account and formed the account had accrued during the marriage. And therefore, when the withdrawals were made, this was not a gain or a benefit because the person who accrued the account already owned it and had created that account.
But this accrued during the marriage too.
Well, it didn't accrue here's the crucial point. It did not accrue as a result of anything Mr. Schell did. It was a bounty, a bonus, an enhancement. He did not create these funds.
So I just want to make sure I understand the distinction now. So IRAs that are funded during the marriage through marital assets and things of that nature, or just during the marriage, we have to look at the funding mechanism for the IRA, and if it's a gift or an inheritance, then it's income, but if it's not, then it's like McGrath. It's very, you're espousing a very cumbersome rule for the trial courts.
But I think that that's the rule that has come about as a result of this court's rulings in Rogers and subsequently in McGrath. And the reason I say that is because Rogers focused on enhancement of wealth and what that means in terms of whether property, money in particular, should be considered in calculating child support. In McGrath, the focus became, is it an enhancement or not? If the person actually owned the funds, formed the account, and then withdrew them. That is not the situation we have in this case. Mark Schell did not form the account. He inherited it. It was a gift from his deceased mother. Did it enhance his wealth? Yes, it did. Did it enhance his wealth because of anything that he did to contribute to this asset? No. It was simply a bounty bestowed upon him that he, for some reason, does not want his children to share. And I believe it is important that this court realize exactly how this case came before it. In 2016, in fact, in October of 2016, the trial court first entered its judgment of dissolution. Within 6 months, Mark Schell filed to reduce the child support for his 5 children that the trial court had ordered. In response to that, Sandra, realizing that Mark was starting...
Counsel, could you stand in front of the microphone?
Oh, I'm sorry.
Thank you.
Counsel, realizing that Mark was starting to withdraw from the IRAs his mother had left him, realized that his income, even though he was asking to reduce his support, had actually gone up as a result of the funds his mother had left him. And in his response to Sandra's petition, Mark never raised the issue that this case had already been decided by the trial court. And in fact, this case is before you today because Mark joined in the request for a certified question. So if he's claiming that because the trial court did not address the issue, or Sandra didn't raise it, I wasn't trial counsel, but that Sandra didn't raise it, then that is a disingenuous argument. He has known all along that this issue was before the court, has never disputed that it should not be before the court, and has joined in requesting a resolution. This court has a unique opportunity to resolve 2 crucial issues in child support cases. Number 1, whether or not inheritance is more akin to a gift as opposed to any other form of income. And I submit to you under Rogers, it can't be viewed any other way. Inheritance enhances a parent's wealth. So assuming we've crossed that hurdle, assuming that issue is resolved based on this court's analysis in Rogers, that leaves us with a determination, which is unsettled in Illinois, about retirement withdrawals. I submit to you, there's a distinction that must be acknowledged between retirement accounts that have accrued as a result of one taking income, just as you mentioned, double dipping, one taking income that possibly had already been imputed for child support and then placing it in a retirement account. If the husband, for example, during the marriage is with his family, he is supporting his kids, and he is saving money, that is an entirely different situation, because we can assume that a portion of his money has already gone to the support of his children. In Mark Schell's case, however, this is not money that could ever have been imputed to him previously for the purpose of child support. There is no risk of double dipping like there was in McGrath, like there has been in many of the cases that have caused consternation among the appellate courts. In this particular case, Mark Schell contributed not one dime to those IRAs that he inherited. And therefore, the withdrawals that he now gets are nothing but pure bounty to him. And we are talking about $10,000 a year that should be shared to enhance the quality of life for his children. It is just a situation in Rogers. It is a gift that he received, and it has the opportunity to enhance his children's lives.
Nothing to keep you from filing a petition to deviate from guidelines?
No, there isn't.
With a windfall, really?
I'm sorry.
I mean, there's nothing to file a petition to say, you know, look at this, all this income he's getting, and he's only giving so much for child support, and our children are suffering. Please deviate from guidelines.
Well, I certainly think that that's one way to approach it, but as I believe Rogers indicates, I don't think it's the only way to approach it. I think that under the ruling in Rogers, regardless of what the source of the funds is, as long as it's not an issue of double dipping, such as it could be in McGrath or many of the other cases, where the funds are a gift or an inheritance, the issue of double dipping isn't there. I think that it's just that money should be considered a gift, unfortunately, through the death of a family member, but nonetheless, an absolute increase in wealth that could not have already been imputed for the purpose of child support. I believe, under the facts of this case, that, and this court's rulings in Rogers and McGrath, that the court has an opportunity to clear the waters that are certainly muddied with differing opinions from the various appellate districts, and finally put to rest the issue of whether inheritance, as suggested by the 5th District in Fortner, should be declared akin to a gift and therefore income under 505A for the purpose of calculating child support. I further believe that it would certainly create judicial uniformity if this court would address the type of analysis that needs to be conducted to determine whether withdrawals from a retirement account should be included in income for purposes of child support, and under what conditions. If the withdrawal is, I submit to you, if the withdrawal is from funds that could not possibly have been previously imputed for the purpose of child support, it should be considered under the terms of Rogers and should be counted as income for purposes of calculating child support. I believe that it's public policy of the state of Illinois to consider what situations, in fairness to the litigants, will provide for their children in the best manner possible first and foremost. And I believe what I have proposed to you on behalf of my client would be most fair to the Schell children and to litigants facing this in the future. Thank you.
Would some of these withdrawals be part of one thing and then part of another thing? Your opposing counsel seems to think it could be that. In other words, there's the inherited amount, X, and then there's the increase in X if there is an increase or a decrease in X.
I submit to you that because any increase from interest, dividends would be attributable to those funds, I believe the same analysis should apply. That if the original funds could not possibly have been imputed for purposes of child support, that any increase or improvement or increment to those funds should also be included in the calculation of child support. Yes.
So both would be available for child support.
Yes, I would suggest that, Your Honor. And I want to also address counsel's argument that, well, you know, these accounts, the value could drop. Well, I think the court also addressed this issue in Rogers. Income's never a guarantee. Values go up and down. In this particular case, if the funds are there to withdraw, it's incumbent upon a trial court to look at the financial situation of the parties at time of trial, not a what if this could happen in the future. It's what the present is that matters. And to suggest that, well, Mr. Schell could lose his $615,000 of inheritance, and then where would he be? That's irrelevant for our purposes. It's what his financial situation is now, and that's what matters, and that's what matters to the welfare of his children. I would also like to point out that with his suggestion that Sandra knew this, Sandra knew that at time of trial and didn't ask for that inheritance, I would direct the court to A31, which is a page in the judgment wherein the assets of Mr. Schell are identified. I submit to you his inheritance is not included in that list. I was not trial counsel, and I don't know why, but Ms. Schell and the court were not apprised of $615,000 in Mr. Schell's account, according to the judgment of 10/11/16.
If the father received a house, inherited a house, and with an adjoining lot, if he received rent for renting out the house, what would the rent be? Or if he sold the adjoining lot and the house and the adjoining lot were non-marital property, what would that be?
Your Honor, I submit that it would be income.
Both ways? Both the rent and if he sold the adjoining lot?
Absolutely, and I believe it would be income because if, after deducting expenses, if he realized a profit and enhancement to his wealth.
But the house and lot would have a value when he inherited the property, correct?
Yes,
And that would be considered non-marital, correct?
non-marital, and I you know, that non-marital classification does not make it removed from consideration for purposes of child support. Just because somebody, let me put it this way. Everything that someone earns after a judgment of dissolution is technically non-marital property. If we allow someone to escape consideration for child support, imputation of child support on non-marital property, then once a judgment of dissolution occurs, children can't share in the income or wealth of their parents
But if
because everything is non-marital from that point on.
If the house is sold, would that be?
If the house is
If
sold,
the house and lot were sold, if it was non-marital property and the person sold the house and lot,
it would still be income for purposes of
the
child
whole
support.
thing would be income for child support purposes.
Yes, Your Honor, if it increased after, I'm assuming there would be an adjustment based on expense of upkeep and that type of thing. But if it overall increased the wealth of that parent, I think under the ruling in Rogers, that it would be income for purposes of child support. Absolutely. Thank you.
Thank you, Ms. Fisk. Mr. Hudson?
Thank you, Your Honors. Initially, I would like to point out, as opposing counsel has stated, that in the judgment, it never recognized that Mark had inherited these accounts. On appendix page 29, which is attached to my brief and is also page 9 of the October 11, 2016 order, paragraph 19, the court says, in 2014, Mark inherited in excess of $615,000 from his deceased mother. Specifically, Mark inherited a Bank of America checking account, a money market account, a Vanguard account, a TD Ameritrade account, a Vanguard IRA, and a Vanguard Roth IRA. The parties stipulate, and the court finds that this is the Mark's non-marital property, as it was never commingled with marital property. The court also notes that Mark will receive additional monies through his inheritance after the sale of property held in trust at some unknown time in the future. So it was mentioned. The court did consider it. It's specifically listed in the judgment of dissolution.
As non-marital property.
As non-marital property.
So the question then becomes, can non-marital property be calculated into the child support equation?
I think that depends on the type of property. So I think as in Rogers, the gifts, those were non-marital property, but they were gifts. The money wasn't the individuals. The money was coming from his parents in increments at that time. So each new increment could potentially be an argument that it was income. The difference in this case is that the money was inherited in a lump sum prior to the divorce even being filed. It was inherited. It was an asset of Mark's that was awarded to him. The court can still consider it. The court could consider it for deviation. I agree with that. But it is not income. Simply the nature of having these funds returned to you, I do not believe is income. And to address the question that the justice had asked Ms. Fisk, I agree that rent from a house would probably be deemed income. I believe that a rent from an inherited home would probably be deemed income. I do not agree that the sale of property would be deemed income. I believe that the sale of an inherited property, an inherited home, once sold, I do not believe that that would be income for child support purposes. I do believe that you could consider it, as Ms. Fisk stated, the financial situations of the parties. It's incumbent on the trial court, she said, to consider the financial situation of the parties. That's a deviation factor. The financial situation of the parties is exactly what that is. When Ms. Fisk was up here, she was talking about the McGrath case. The McGrath case, the divorce was entered in 2007. The modification, I believe, was in 2010. I don't recall there being any issue of double dipping. The question was whether or not they could look at those funds, whether or not they could look at those savings account withdrawals in order to deviate, and that's what the court did in that case. They didn't say that the account withdrawals were income. They said that we can deviate, and the trial court could deviate based on the resources, the financial situation of the parties. There's been a lot of argument about supporting his kids. In the judgment of dissolution, Mark was ordered to pay almost $3,000 a month, over a third of what he was actually earning at that time for child support and maintenance. At the time, not all 5 children were still minors. A couple of them had been emancipated at that time. So the court did consider it. The judgment itself shows that they consider it. The motions to reconsider filed by Sandra specifically restated Mark has $614,000 in non-marital funds. That should be turned over to us. A portion of it should be turned over for child support purposes. And the court denied that on both occasions in December of 2017. Those judgments were never appealed. Those judgments weren't appealed. It was not appealed until sometime later on a petition to modify. The Circuit Court of St. Clair County stated that they weren't going to look at the withdrawals. They did say, we're going to look at the dividends and interest. So any dividends and interest off those accounts, we're going to consider. We're not going to consider the mandatory withdrawals that are essentially a return of principal. In the 5th District's ruling as well, they say that had the trial court originally imputed the income on Mr. Schell that their ruling would have been different, that had they considered and imputed the income, if they're imputing income, it's not actually income. Imputed income is not income. It's you're giving somebody an amount of income because you believe they could receive this. So I would disagree with their statement there. It was considered. It was absolutely considered. It's in the judgment of dissolution. It was considered. The court decided not to deviate. They don't have to lay out their reasons for non-deviation in the judgment. They only have to lay out their reasons if they do deviate. Additionally, it's not an increase in wealth. There's not an increase in wealth by merely receiving what you're already owned. And that would be our position today, Your Honors. Our position would be that these withdrawals and this account, IRA accounts, should be used to determine the financial situation of the parties if deviation is necessary. The court should consider them. It is not income. The mere definition of income, the income definition given in Mayfield, that it has to enhance the wealth, the definition that the court laid out in McGrath saying that it's not income if it already belongs to an individual and you're merely taking money that belongs to you. We don't believe it gets past the income hurdle. We do believe that it could be considered for deviation. We believe that the statute is clear that you can consider the financial resources of the parties for deviation. And so we're here today. Ms. Schell's attorney suggested that this would create judicial uniformity. We're here to request judicial economy. It would be much simpler, much easier to not have to bring these accountants, these actuaries into court every single hearing to let us know which portion that he withdrew, what part of that was from the increase, what part of it was from the decrease, what part of it was from funds he put in. It's basically going to come to that every single court hearing to determine child support and maintenance. In addition, you can modify it every month, depending on what the market does. You look at your accounts and you say, hey, I'm down $100,000. Let's file a petition to modify. You're right back in the same boat. For judicial economy purposes, the IRAs need to be treated as a factor when considering deviation. And that would be our argument here today. We're asking that you overturn the 5th District Appellate Court's ruling and reinstate the trial court's ruling. Thank you, Your Honors.
Thank you, counsel. Case number 126802, in re the marriage of Sandra D. Dahm-Schell and Mark R. Schell, will be taken under advisement as agenda number 19. Thank you, Mr. Hudson, and thank you, Ms. Fisk, for your arguments this morning.